panel is on industry-specific experience in arbitration in India. For this, may I please invite on stage our moderators, Justice Rebello, former Chief Justice of the Allahabad High Court, Mr. Pramod Nair, Managing Partner at Arista Chambers, Mr. Philip Capper, Partner at White & Case, Mr. Shai Wade, Partner at Stevenson, Harwood, Mr. Mysore Prasanna, Senior Advisor at Aarna Law, Mr. Ganesh Chandru, Executive Partner and Head of International Arbitration at Lakshmikumaran and Sridharan.
Good morning, everybody. We shall be dealing with the subject, namely industry-specific arbitration and the expertise which is required in that field. In that context, while the speakers will be dealing with their specific knowledge of the subject in the specific area of their expertise, we shall thereafter also consider the issue as to whether, considering the expertise of the particular field, whether you should have arbitrators who are industry specific or arbitrators having a legal knowledge like lawyers or judges, or a blend of both. So with this introduction, and I think we start with that each of the speakers will have some time to dwell on the subject of their choice. Let me start with whom? Campbell. I think we shall start with Mr. Philip Capper, Partner, Right and Case.
Well, thank you very much, Mr. Chairman. Good afternoon, ladies and gentlemen. It's a great privilege to be asked to come and share in this second annual conference of the MCIA. It's not only a privilege to be here, but it's a pleasure to congratulate the MCIA on its development and success. I've been asked to say a few words by way of introduction as to what makes arbitration on construction and engineering projects, major infrastructure projects, different. Well, as you all know, the single most distinguishing feature of such projects is that it is economically not feasible to know at the time you enter into a contract what will be the eventual scope of work. That is the single most distinguishing feature. What effect does that have? Well, change management and time management become the most crucial issues on the project. And behind me it says the changing landscape of arbitration in India. Certain things don't change. The degree of change and the lapse of time on projects are unavoidable. Their management is today changing and improving, but I regret to say disputes are inevitable. What other features distinguish construction? Well, at least two others are relevant to arbitration. The first is the multi-party nature, this temporary coalition of teams that come to work on the design, construction, and delivery of a project. But also, there is an unusual interdependence of these projects on external factors, external bodies, external environments, external permissions. And that's why I continue to say that disputes are inevitable. Is there anything else that's changing? Well, we've already talked at the end of the previous session about ways of achieving fast determination of key issues. And such projects do require fast determination on key issues. Is the employer entitled to interfere with the selection of subcontractors? Must that viaduct be demolished and rebuilt? Is a takeover certificate now to be issued? Can the employer lawfully call that bond? Litigation will not solve those questions. And the challenge is whether arbitration can solve those problems. So we are seeing a constant search for fast techniques, ideally that work well with arbitration. And we discussed multi-tier dispute resolution provisions. Where the FIDIC contracts are being used, the International Federation of Consulting Engineers contracts that you know very well in India, where the FIDIC contracts are being used, the old engineer's decision has given way to dispute adjudication boards. It's already been mentioned, and I'm sure we'll mention it again, one of the greatest difficulties in my field of arbitrating international infrastructure projects is the interface between dispute adjudication boards or other pre-arbitral steps and the arbitration itself. What difference does it make to arbitration that we're dealing with a major infrastructure project? Well, apart from those pre-arbitral step problems, the huge question is how to deal with the evidence. And this confronts us on document production. It confronts us on the inevitable use of experts, of which we will hear more later in the day. And it presents very real questions about the selection of arbitrators, their qualifications, and their ability to manage what are typically long arbitrations, heavy arbitrations, and ones which therefore typically get split. They get bifurcated. They get bifurcated into the admissibility questions, the liability and quantum issues, but often procedural steps as well. So with those few thoughts on what makes infrastructure arbitration different, I pass back. Thank you.
Thanks, Philip, for that. Moving on from construction and engineering disputes, could I request Shai Wade to speak about the particular characteristics of oil and gas disputes, and specifically upstream oil and gas disputes?
Good afternoon. Thank you very much to MCIA for inviting me to speak here. It's a pleasure and a privilege. Touching very briefly on upstream oil and gas arbitration, and if I have time, I will also perhaps touch on a different type of arbitration, which is commodity arbitration. And my thoughts are centering on what we need to know and do to successfully arbitrate disputes in those sectors. And my overall thesis is that to do this well, you have to understand two things. You have to understand the economics behind the transaction and the contracts that have evolved through the economic requirements relating to the industry. So in the case of upstream oil and gas, we have for the past 150 years or so worldwide been dominated by the process of searching for and producing upstream oil and gas, or in the upstream sector. And to know and understand how to advance those arbitrations, we need to understand the contracts that have evolved through the economic and now more often than not political pressures that are involved in that process. So we have to understand production sharing agreements which involve governments. We have to understand the relationships between parties that come together to explore for and produce oil, joint operating agreements, farm in, farm out agreements, joint bidding agreements. But we also have to understand the technical process, which is often highly complex. We need to know to understand and sometimes even read seismic production contracts, so how that process occurs and what it looks like on paper. We need to understand the technical side of extracting oil from the ground, be it onshore or offshore. And so these are areas which require a great deal of technical expertise, which, without which we probably fail in conducting an arbitral process that is efficient and cost-effective. At the other end of the cost and profit spectrum often is the world of commodity arbitration. Now, if we say that the world has been dominated by hydrocarbons for the past century or 2 centuries, then international trade has dominated our life for far longer, probably from before the advent of the modern nation state even, and certainly from the very beginning of shipping. And to understand and lead arbitrations successfully in that sector, again, we also need to understand the economic pressures that operate and bring about the international trade, and the technical aspects of bringing large quantities of one product from one part of the world to the other. So we need to understand here the modes of finance, and we need to understand the modes of transport, and we need to understand the sales contracts that have developed around this area. And this is a peculiar area where the level of, in relation to disputes in particular, the level of cost or amounts in disputes tends to be far lower than other areas of arbitrations we see. And yet the level of expertise in relation to the conduct of these disputes is far higher often than other types of arbitration which we come across. This is an area of practice where each particular contract of commodity has developed a separate type of arbitration with specialized arbitrators from that field alone, an area in which arbitration has internal appeals procedures, an area in which we need to understand not only the type of commodity which is being dealt with and its particular features, but also the roles of shipmasters, the roles of shipping contracts, and shipping surveyors. At that point, I'll pass on.
Thanks, Shai. Now to localize the discussion, Ganesh, could I ask you if there are any India-specific nuances to oil and gas disputes that you've seen in your practice?
Thanks, Pramod. There are, what I'm going to focus on is, Shai spoke about upstream issues and upstream oil and gas. When it comes to disputes, we are talking about industry-specific arbitrations, and whereas in upstream you really require that expertise. Whereas in disputes which arise out of the oil and gas industry here in India, I think it's a lot of role that lawyers play. The way you interpret the contract, the jargons used in these contracts, because some of these contracts are not, there are a lot of room for interpretation. So that's typically how most of these disputes are played out. But the kind of issues that time and again raised is, if there's a delay in completion of project. There's a delay in completion of project, obviously, the employer is going to say that it's the contractor who delayed, and therefore they withhold monies for liquidated damages, which are typically encompassed in these contracts. Whereas the contractor would say, oh no, you had ordered additional works, and this is a variation to what was agreed between us. This is typically, the kind of, these are some of the issues that do arise. And when you're looking at offshore projects, when, for platforms or laying of pipelines, there's a lot of other issues. For example, the contractor's vessels may be there. There may be other vessels for other contracts which are operating in the same area. There may be interface issues, which are typically, that the part of the disputes between the parties. So at the end of the day, it all revolves around these issues, which I come across quite often in oil and gas disputes. To just distinguish that from another sector, Pramod, if I may just move into that, disputes arising out of highway projects in India, for example. It's very unique to India that it's not just a project that is awarded. A lot of government involvement is there, both the central government and the respective state governments. So right from land acquisition issues by the authority, usually there's a concession agreement given by to a particular concessionaire to develop a particular highway. There could be issues of non-collection of toll, which may be a big issue. Typically in such contracts, there's a force majeure clause, and either party kind of tries to invoke that and says there was a force majeure. So force majeure is not necessarily something like act of God, which is a non-political event. In most of these contracts, there are indirect political events and political events that are part of force majeure. For example, you look at strikes, or if there's demonstrations, that could be an indirect political event. But for example, there's an order from the government or from the court, revoking a permit that could, be interpreted as a political event. So these are things, and termination of the project is another major issue in highway projects, because based on force majeure, even they could terminate the contract, either party, and then the question really arises is how do you determine the termination payment? So there sometimes you would require expertise, which is also required not only in this but also in oil and gas. So these are the two sectors, I think, in my practice, I think they are very, very interesting issues. And I think the lawyers and arbitrators, there's a lot of role to play by both in how the contract is interpreted.
In our growing economy, mergers and acquisitions are an important aspect. We have Mr. Mysore Prasanna, Senior Advisor, Aarna Law, to speak on the subject. May you please share your thoughts?
Thank you. A couple of caveats. Number one, I was asked to jump into this seat last night. So, number two, I've always been a general counsel, and it's only in the recent past that I have been engaged in private corporate practice and also as an arbitrator in various international commercial disputes. From my experience, M&A is typically has a very high potential for disputes if the relationship between the parties is not managed efficiently. So more than anything else, the overarching requirement in an M&A transaction is to preserve that element of trust which will make parties understand each other and carry on. It's said very often that a 50-50 joint venture is a recipe for disaster. And unfortunately, there has been sufficient examples of that being true. And a lot of people who have entered into joint ventures in India with various parties have experienced that difficulty. And so whether arbitration is going to really help them, or whether they would like to at clauses and have some kind of an exit, it's a huge challenge and you can never get it right. Cross-border M&A will have a different kind of problem, particularly if it is inbound, then you have various issues. If you are outbound, if you are doing joint ventures in different jurisdictions like China or various other things, the biggest challenge is, of course, language, and to get everything right is extremely difficult. So one of the things as a general counsel I used to actually ask is, before signing up to an arbitration clause, what do I do? Is it good to arbitrate or is it good to litigate? The dispute resolution became a strategic issue than a boilerplate approach. I'm not going to bung in an arbitration clause because it's a midnight clause and we're all tired and we want to be done with it and we want to get to the signing page. So that, in fact, in my opinion, is an extremely important step to consider the overall context of the contract and to see whether you really need an arbitration clause or whether, given the facts and circumstances of the case, whether you're actually good to have a open-ended clause. Because as general counsel, I felt it's not necessary for me to have an arbitration clause today. I can always think about arbitration when disputes arise. Until then, I'll keep my options open. So there are different ways different general counsel think, depending upon in which industry they actually are in. Areas like technical collaboration. One of the dispute is all about whether one of the parties has indulged in reverse engineering. The question of non-compete. Is there a breach of non-compete? And is that non-compete provision really enforceable, given its kind of an overreach in terms of geography, in terms of time period and all that stuff? That's another area where it could be a problem for arbitrators to really get it right. Valuation is another big area where people always have problems. And there are two experts expressing three opinions. And the arbitrator is simply lost as to how to get it right, which opinion should actually prevail. You can never get it right. It's absolutely difficult to have it decided in a perfect manner. And so there are a number of issues in mergers and acquisitions, and there are unincorporated joint ventures. For example, I've been a party to unincorporated joint ventures where there have been oil field, where two people come together to operate an oil field. And if they have a dispute, what happens to the relationship of this venture with the government? It's a big, difficult issue to deal with. So it all depends upon how well the M&A agreement actually provides for it. There could be share purchase agreement disputes, share subscription agreement disputes, post-closing disputes. You can imagine any kind of dispute. They are all there in M&A, different hues and colors. So to conclude, it has a significant potential for disputes, but if it is well managed, I think the disputes can be minimized.
Thanks, Pres. Now, with that overview, I think maybe it's a good idea to discuss about some general issues which might straddle each of these industry sectors. And probably the best way to get to the bottom of some of those issues would be to ask you very specific questions. So to take a step back, given the various industries that we've discussed, are there any industry-specific tweaks that you would make to an arbitration clause? Or would a boilerplate arbitration clause work just as well in each of the industries that you've described? So we can probably start again with Philip and then go around in the same order in respect of each of the industries that you provide an overview on.
2 points. First, almost certainly some form of structured multi-tier escalation of disputes, some form of relationship of the arbitration agreement to a faster interim step. Second point, Don't say anything else.
So I've introduced two different industries, and they're very different in their approach. The upstream oil and gas industry tends to be very non-prescriptive, adopting boilerplate with no amendment. And in my experience, on the whole, that works very well. It allows arbitrators, it allows the parties to choose arbitrators who understand the industry, and then it allows the arbitrators to conduct proceedings that are relevant to the particular dispute without being constrained to a great degree. On the other hand, the commodities industry is very prescriptive. It tells you who you can appoint, it tells them what they can do, and then it allows you probably to appeal their decision as well. And whilst as advocate I find that a rather frustrating way to go around things, for the industry it has worked for many generations very well. So sometimes I wonder whether the rest of us can learn something from the greater degree of specificity in arbitration clauses.
Thanks, Shai. Ganesh?
I think as Philip rightly pointed out, it's very important to have a clear clause. You know, he rightly said, don't say anything else. Like this gentleman in the previous session raised a question, what if the clause says refer it to an architect, then leave it open-ended. So I would think, see, if you look at most of the arbitration clauses or dispute resolution clauses rather, in either in oil and gas or be it in road projects or any other major big project itself, usually typically there's a clause for negotiation prior to the proper dispute resolution. Sometimes they talk about conciliation or mediation. It is indeed good to have an escalation clause, but the most important thing, it has to be clear so that that doesn't arise to a lot of disputes in itself. So it may be very, very important for the parties to discuss that bit if they are going to put negotiation, who's going to be negotiating. Sometimes it says top management. What is top management? You know, how many days? They need to say, you tried for 30 days. There has to be clarity there. If it's mediation, again, please be clear if you're choosing an institution, for example, for mediation, then you need to put that in. Then arbitration, there has to be clarity as well. I think one other thing is, the previous session I also heard about this, there was a question on one of these cases in India about multi-tier arbitration, two-tier arbitration rather. I think, in my view, I think that should be completely avoided because then you are, you know, going through the process all over again, like Rohini pointed out. I mean, you don't want, you're commercial people, you don't want to be arbitrating between one center and then go and act before another center. It's not some cinema shooting. So I guess you need to be extremely careful when you draft this clause, and you know, it's good to have escalation clause actually, but it has to be clear. That would be the message.
Yeah, I've always believed in having a kind of a tiered approach to dispute resolution. In fact, the starting point is about the good faith resolution, the two parties actually coming together and to find out, particularly if there's a very strong difference of opinion at the board level, it is much better to have a mechanism where that matter is actually referred to the two principals, the two shareholders. And the shareholders can then take an organizational view as to how that particular issue should be resolved. More often than not, it does get resolved because in the board, the nominee directors may have a difference of opinion or they may not like each other's face. But the point is you need to find out some way to diffuse that particular tension. And I agree with Ganesh because I am also a firm believer that mediation is one of the important things that is actually gaining ground in India. And I think a tiered approach to dispute resolution which contains the mediation process is extremely important. And I think SIMC, in fact, is one of the examples as to how mediation has actually played a big role in making sure that relationships continue and not really go really out of hand. Thank you.
Thanks. An arbitrator in the contract or specify qualifications or attributes that an arbitrator must have, or is it best to leave it to an institution than to determine who might be the best arbitrator for a particular dispute? Probably we could start off with Shai and then just go around the rest of the panel with that.
I get to skip you this time. So my views on choice of arbitrators is as far as possible, never predetermine the attributes or the people who you wish to have appointed. As far as possible, leave that in the hands of the parties and leave that decision to be made after the dispute has arisen. I am not a great believer in institutional choices. I understand the pressures that come from the requirements of impartiality, and yet I also believe, and my clients often tell me that they want to have some buy-in into the process of choosing arbitrators so that they personally have trust in at least one of the members of the panel. In that regard, I think that the commodities style arbitration panels are probably the wrong way forward to go. And yet, where they have struck a chord with me is that I believe also that the choice you do make after the dispute has arose should be a person who understands the ins and outs of the nature of the contract you are dealing with. If you are arbitrating about an upstream oil and gas contract, and your arbitrator doesn't know the difference between an OPCOM, FinCon, or carry or a cash call, then you will have to spend a lot of time educating them, which you would probably rather avoid.
Perhaps again 2 points, but may I be indulged? The first point is a very short war story, where a telephone call gave me what I think was my best compliment in my life, and I should say that I'm just a lawyer. I've only ever studied law and taught law. But a gentleman phoned me, introduced himself. He's an American counsel. He said, "You won't remember me." I said, "No, I do remember you." He said, "You had been the sole arbitrator on an arbitration." Yes, it was about a silicon manufacturing plant in France. Yes, I remember. He said, "Well, how can I help you?" He said, "Well, I want to appoint an arbitrator." Very good. And he said, "We have an unusual clause. The clause specifies one lawyer, one accountant, and one engineer." Very good. He said, "Well, we've appointed the lawyer and we appointed the accountant, and so that's why I'm calling you." And I said, "Sorry, I don't understand." He said, "Well, we need an engineer. You understood about that manufacturing plant. We would like to appoint you." And I said, "Well, but I'm a lawyer." He said, "Well, are you not an engineer?" And I said, "No." And here came the compliment. He said, "Are you sure?" Well, you can get some meaning out of all of that, that I would join my colleagues in saying not to specify the qualities or characteristics of the arbitrators. But my second point is this, and this is a real practical problem that one observes as counsel, and that is that you can get quite difficult asymmetries in three arbitrator tribunals. Especially if one of the parties appoints a very dedicated technical specialist, and then you're left, say, with two lawyers, and that party could even be an engineer qualified lawyer, and then the remainder of the tribunal are two lawyers. And that gives rise to difficulties if the chair relies too much, for example, on the technically qualified person. There are some practical difficulties there.
I just have one point, because I think we are running out of time. So I think most of the points have been covered. I guess one issue which was raised this morning during the inaugural session by Mr. Mandal was he did mention that many people in India mentioned that arbitration has been hijacked by lawyers. It's actually the industry people who need to be involved in the decision-making process. It is definitely a good point, but in the Indian context, what is required is a lot of engineers sit as arbitrators for smaller disputes, but I guess a very important aspect is they need to go through the training as to how to write an enforceable award. If they're technically qualified, fantastic, but at the end of the day, you need to make a decision, right? So I guess that's where I think MCIA is doing a fantastic job by having started this training process. So I guess going through this training, even Chartered Institute of Arbitrators in India is also conducting training programs. I think that is very, very essential if that dream has to be a reality of not just having the legal profession, but also others from the industry becoming arbitrators.
Very quickly, M&A, as you know, is marriage and annulment. So it's a question of trying to preserve the marriage and not get it annulled. So I would certainly go for mediation. I'm increasingly believing in mediation as a way of making sure the marriage continues. Otherwise, if it has to go to arbitration, I never will appoint experts as arbitrators. I find it very, very difficult because if two experts end up being arbitrators, you can imagine what a chaos it'll be. So I would rather have experts play their role assisting the arbitrators, or arbitrators themselves appointing an expert in order to determine some of the issues like valuation, post-closing adjustments. And in fact, there was one case, very quickly, there was a breach of confidentiality that actually one party alleged that the confidentiality breach resulted in diminution in shareholder value. It was absolutely a mind-blowing case where the arbitrator, a lawyer, and another two judges, all ad hoc arbitration, they have absolutely no clue as to how this diminution in value can happen if it's a breach of confidentiality. So the experts had to be brought in, but the experts just could not get it right. So it's a very, very tricky situation as to, you can never get it right, but you need to think through and perhaps get inspired by international precedents and see how to handle it. Thank you.
Just to add to this, a personal experience, I was the presiding arbitrator and I had two architects by my side as co-arbitrators. The matter was heard and finally, I have the two architects giving me two different advices, diametrically opposite to each other. So much for the experts. Now, having said so, we would like to ask the audience any questions. They would like to ask any questions. Yes, please.
I'm Nishikant Deshpande from Pune. I'm a domain expert arbitrator. I agree with the views of the panel that if you have expert arbitrators, they should be probably trained in the process of arbitration by a reputed institution, say permanent arbitral institution. I am qualified with CIRB London, but our experience is very bad. I am also empaneled with the Bombay High Court as also Delhi High Court. We do not get any such assignments. There is a sort of coterie, and what was said earlier by Mr. Mandal was right, that the arbitration process has been hijacked by lawyers. Now, I don't want any comment on this one because it's a fact I'm saying it. And I just want to share about industry specific. So about power sector we didn't discuss. I would just like to share the experience. Recently, there was a multi-crore dispute between a Pune-based company and a government of India. It was relating to nuclear power. There were four disputes, but two major were, one, that if the contract has been signed at a particular level of the employer, then he would nominate the arbitrator from a panel. If not, it would be the ministry, relevant ministry who would appoint. When the dispute actually arose, we found out that neither of them had maintained any kind of panel. And then it had to go to the High Court for appointment of arbitrator under Section 11, but the project was of strategic importance and they could not have gone and wasted time. So ultimately, since both wanted to continue with the relationship, they had to go for mediation, and then a person like me could successfully mediate in 2 months. Thank you.
Any other questions, please? But kindly be specific to the questions, not, we can share, of course, your experience. Are there any questions? It looks like people are hungry, and with that, I think we bring the session to an end. Thank you very much, and thank all the panelists for that.